I'll try calling it again while you guys get comfortable. Our second case today is Lee County, Florida versus Captiva Civic Association, Inc. and WWSSIR owner, LLC. It's case number 25-0335. As counsel is aware, you're permitted 20 minutes to make your argument. You can allot a certain time for rebuttal. How much time would you like to reserve?
I'd like to reserve 4 minutes for rebuttal.
Whenever you're ready, counsel, you may begin.
May it please the court, my name is Chris Altenburn. Along with my partner Eleanor Sills, who could not attend today, we represent Lee County. At appellant's table is Hala Sandridge, who represents the intervener SSIR. She won't be arguing today. Technically, she's an appellant, but, she's an appellee, but on these issues, she is more aligned, or her client's more aligned with the county than it is with the Civic Association. This case involves the interpretation of a contract that was signed by Lee County and by the Captiva Civic Association. That contract's a mediation agreement. It was filed in circuit court in 2003 to settle a then pending lawsuit. The sole consideration for that agreement was the dismissal of that lawsuit. No judgment was ever entered in that lawsuit, and the mediation agreement itself was never ever reported in public records to give anyone in the public notice that it existed. But 21 years later, the Civic Association filed a lawsuit against Lee County, claiming that one sentence in the middle of paragraph 3 provided that the association had a vested legal right at any time in the future to block the county from issuing a building permit in the event that in the South Seas Resort District there were more than 914 dwelling units. Now, 914 dwelling units was at that time, because of the land use code and due to a resolution passed in 1973, it was the limit of dwelling units in that particular zoning district. But the association is claiming that not only does it have a vested right to do that when that is the law, but that even if the county commission has or in the future changes the land use code to some other density, it still has the right to enjoin the county, the building department, from obeying the lawful ordinances of the county commission, and to prevent a then property owner of the property in question, who has fully complied with all applicable laws to be able to obtain a building permit, that it can prevent that building permit from being issued.
Am I correct, counsel, that there's nothing in the mediation, or do you concede this or not, that there's nothing really expressly limiting in the mediation agreement to current codes or existing ordinances? You know, there's no language, I think, that would really help you probably in your argument, you know, unless and until the ordinances change or something like that. I mean, it seems to me that if you just took the mediation agreement at face value, we just look at the plain language, I'm not even sure we have to myopically look at certain sentences in there. It seems like there's nothing truly limiting it to existing codes. You contest that?
What I contest is how we interpret this under Connage. And the trial court used the plain and unambiguous standard, and I would suggest that even under Holly versus all, this was incorrect. But that standard, as you know, goes to first principles, and the words of the governing text are paramount concern, and what they convey in their context is what the text means. And in doing that, you take a look at all the textual and structural clues that bear on the meaning. So in this case, this one sentence, and specifically the words "at any time," are in the context of a mediation agreement that's settling various things related to the contract. I do think the contract, by the way, is part of the context. I don't think anything beyond this agreement and the complaint are part of the context.
You think the complaint's part of that plain language that we're to construe?
I don't think you can read the mediation agreement, about 2/3 of it, without understanding what the complaint does, because it's resolving things that were disputed there. So, for example, on the language about there's 104 or 2 units in one of those dwelling buildings. Well, that was a fight over whether it was that number or that they thought it was a higher number. So it's really hard to look at this agreement as a mediation agreement, knowing how they're prepared to look at it without at least taking a look at the complaint itself.
Could you prevail just with regard to your argument about interpretation if we decline to look at the complaint because we would disagree, if we disagree?
I think so. I think so.
Okay.
I mean, I think it's kind of like an exhibit, though, so I think you should. But even if you don't, if we take a look at this agreement for the clues as to what's going on, their argument is, now keep in mind, no one's claiming this was something that was in that complaint or that they were mediating to resolve that they're claiming that they could have this right, even though I've pointed this out, not only did they not raise it in the complaint, but no trial court would have ever given them this right to have the ability to control the building department when the law allowed for that to take place. So we're dealing with an agreement that they say is, well, it's outside the complaint. Fine. You can do that in a mediation agreement. I've done that in a mediation agreement. But you know, when it's something as huge as giving control of the building department to a nonprofit association, you'd think it would be in a little paragraph of its own that said, in addition to settling the things that the mediator is settling in the complaint, that we're going to give them this vested right for the indefinite future to be able to prevent a dwelling unit to be permitted for a property owner under existing law, because at this time we're agreeing that there's 912 dwelling units. And that's just, there's no clues in here that this major agreement is in this one sentence in the middle of a paragraph.
Counsel, I'm going to ask this inartfully, so bear with me. Is this akin to somehow a contract which gets pieced together by multiple communications? Is that similar to your argument, or we look
Well,
at?
we've all mediated cases, I suspect, and we don't honestly know whether they sat around at a table and talked to one another, or whether there was a mediator bouncing back and forth in 2003 on this. But what we can say is that the context of how you prepare a mediation agreement is often very, very different than if you were preparing a real estate closing or some other document. So I don't know how this was pieced together, and that would, I guess, require parole evidence if it was needed to do that. Does that answer your question?
Somewhat, thank you.
Okay.
Counsel, can I ask, as the term, building permits is used in the mediation agreement, generally, how would a building permit be obtained in Lee County? I assume it goes through some department of the city, community development or something. Does that then go before a full commission, or is it purely an executive function? Is it also legislative?
The record doesn't tell you that, but
I assume the law would tell us if I dug into the code. I think you could just sort of
Well,
summarize
and
it
I
for me.
can say I was raised in a construction family. The permit is issued by the department. You file all your papers with the department, and they do things within the government to do that. But it's not going to go back to the Board of County Commissioners or whoever is in charge of a municipality and have a vote every time about whether we issue a building permit. That does not happen.
Who is the decision maker then, apart from this agreement being in effect? Who gets to decide whether someone who wants to build on in this South Sea
gonna be
Resort District?
I can't tell you the precise descriptions in this situation, but it's going to be someone in the executive branch of county government that is applying the local law under those ordinances and anything that would be applicable under Florida statutes. That's how this is going to work.
And if there's a proposed builder who presents an application and it complies with all building codes and all ordinances, is there discretion on the part of the county to say no, even
No.
if all obligations have been satisfied?
You know, the property owner has property rights that are given to them in the Florida Constitution by the U.S. Constitution. So if you comply with all laws to do something that is on your property, you're entitled to do it. So they can't say, well, I wish there was something more in the building code or the land use code, so I'm not going to give you a permit. That's just not legal.
And so
Except-
I'm kind of leading you down a path here. My question is, how could this agreement, even in the context in which it was entered into, how could it ever be enforceable to tie a county's hands like
Yeah,
this, to
yeah.
say, we, by agreement with a private association that isn't even a landowner itself, we will agree not to issue building permits, even though they may someone who applies for the permit may otherwise be entitled to it.
Yeah. The answer is that they can't. You're jumping sort of to what I think of as my second issue, which is even if this thing had been written with the paragraph that says, and moreover, in addition to settling the lawsuit, we're going to give you a vested right so that even if we recognize that 914 is what you allege in your complaint and what the law actually is right now, but even if we change the law and make it 1,003, you can keep this at 914 forever, I guess. If we wrote that contract, it's quite patent that we are delegating the power of the county commission to provide the executive branch of local government with guidelines that they're supposed to obey. Those are police powers that we're delegating to a private citizens association. And there's no question that zoning is a police power. So all of the case law that deals with the fact that governments from the highest level to the lowest level cannot delegate their police powers would say that this contract was an ultra-virus, unenforceable contract.
So would your argument be, if this contract was enforceable at all, it would only be in the context of resolving a disputed interpretation of the existing zoning ordinance at the time?
Yes.
As to the number?
Yes.
That's allowed.
The reason it's a second sentence in this paragraph is the total number of dwelling units in South Seas is limited to 912. Well, when they're writing that sentence and signing the agreement, that's absolutely,
Present tense, right.
absolutely is what it is. It doesn't say is and will be or something like that. The next one about no building permits being issued is because they've been having this fight about, in fact, there were building permits that were issued above this number. They're not going to do this anymore. And because they don't know how many, there's been this fight about unit counts. How do you count to 912? They were trying in their complaint to get rid of determination number 1 in the entirety of the July 30th, 2002 administrative interpretation. But in the mediation agreement, they said, at least as to determination 1, we're conceding on that, and that's going to control. And then they went on to do the last 2 on these things. So when you fit this sentence into the paragraph, that's exactly what they're doing under 912. And it doesn't say because that's the law right now, but what they were settling was something that was related to the law at that point in time. So that's my position as to why, if you look at the text in its context to see what meaning it was conveying, it's at this time under this law. It's not that at any time in the future, no matter what gets changed, we get to control these permits. That would be pretty outstanding. Keep in mind that the mediation agreement allowed them to obtain a judgment if they wanted to. If they had actually gotten this agreement that they claimed they got from the county, they would have gone down to the judge and gotten that judgment and put it in public records so everyone knew about it. But for one reason or another, there's no judgment that was ever entered on this. I can confess that I'm old enough to know that in 2003, court files were paper. And they were destroyed under retention policies after, well, it's a civil case, 5 years. The lawyers would have done that. They're signing an agreement on paper knowing that in a few years it's going to be gone. And the concept that that agreement was going to be one that lasted forever after the law was changed makes no sense at all. So my position on the front end of this is that it does not mean what they claimed it meant and what the judge found, that you should issue an opinion that explains that in the context of this paragraph, it was 912 dwelling units because that was what the law was at that moment in time. If you make that holding, by the way, I don't know we need to go on to ultra-virus, but certainly if there needs parole evidence as to what they meant, if what they meant is what we've discussed with Judge Gannon, then it's clearly ultra-virus. You don't need to use parole evidence because there's nothing to go back to look at. So I will
Counsel, for ease of reference, will you tell me, I know you're looking at the mediation agreement right there. Will you tell me what page of the record it is on, so I can
So you
immediately
can do
grab
that,
it?
and I'm sure it's in my appendix as well,
It is.
but it says here, oh, in the copy I have says 19 to 20. You know what, I'll give you that when I get
That's
out to
okay.
reply,
I thought
'cause
you
know
might have it. I thought it might be at the bottom of your
the
page.
appendix- I have the appendix site, but I don't have that.
What's the appendix site, Counsel?
Well, I'm looking at pages 20, 21, and 22
Thank you.
of the appendix.
That's great. Thank you.
And, you know, lastly, I ought to confess that I'm not a big fan of opinions written with alternate holdings. I think they make more trouble than not, but even if you reach the first issue, at least commenting that the second issue about ultra hazardous is something you your concern is something I think we should do. So I'll reserve the rest of my time for rebuttal. Thank you very much.
Good morning, Your Honors. May it please the Court, I'm Steve Brannick of Brannick Berman Insider, representing the appellee, the Capitola Civic Association. Judge Brownlee, to answer your question, the mediation agreement's in the record in a lot of places, but look
Yeah.
at pages 446 to 448.
Thank you.
So, Your Honors, excuse me, the county makes two arguments. First, that the settlement agreement doesn't mean what it says, and secondly, that even if it does, it's unenforceable. So let me first start with what the agreement says. I don't think there's anything remotely ambiguous about the limitation in the agreement. The first two key sentences say that the total number of dwelling units on South Seas Resort is limited to 912. No building permits may be issued for the dwelling units that will cause that number to be exceeded at any time. We're simply asking the court to enforce that plain language, and even the county concedes that the court has to review this agreement, giving supremacy to the text. Now, Lee County says that you should read that 912 limit to say that it's limited to 912 until the county decides to change the zoning.
But what about his point that it says the limit, and I'm trying to listen and pull it up immediately so I can quote it. He's saying it is 912. That's the current limit. And now we're tasked with figuring out how that number works with, you know, this development, right? So what do we do about is 912? What happens when it is 5,000?
Well, there's three sentences. The first sentence says that the current limit is 912. The second sentence says that the county is not going to issue any building permits in excess of 912 at any time. That's a very strong, forward-looking phrase. The county certainly could have negotiated a provision that said it's limited to 912 until the county decides to change the zoning. They didn't do that. You'd have to add words to the agreement, which of course you're not allowed to do. But then we have the third sentence, which states that the determination number 1 of the July 30th, 2002 administrative determination will control, and that determination number 1 is the determination that counts the units at 912 and is the basis for future development. Again, we have very strong language, very clear language, forward-looking language that suggests that 912 is going to be the limit for all time. Again, their argument is that you have to read that to say it's limited to 912 until we decide to change the zoning, but they could have negotiated that, they could have put it in there, and it's not there. That's the fatal flaw in their argument.
Counsel, what if at the time this agreement was entered into, the ordinance at the time permitted 2,000 units, and yet, but the county entered into an agreement with CCA saying we'll never issue building permits beyond 912. Would that have been a legal agreement for the county to enter into? Because it takes the estoppel argument off the table if that was the state of affairs going into it, and so there's no reliance. It's just an agreement at a point in time when they'd be agreeing to issue fewer building permits than the existing ordinance allowed. Would that be legal?
I think you're getting at an important point, and a point that I like to emphasize strongly. That is not the case here. What this agreement did was enforce the status quo that had been in place since the 1973 approval for this development. This development was approved at the request of the developer for 912 units. And that was, and the developer wanted those 912 units, and could have had more, but said, in exchange for the 912 limitation, we're going to do this in a different way. We're going to cluster those units, so we'll have some areas where there'll be high density, and then some areas where there'll be the empty land. That's what the county commission approved, and that's how that development was built, and that's how it was sold to all the folks that bought into that development. And so when the county in 2002 issues its administrative determination, suddenly it looks like the county, through this administrative process, is going to increase that 912 units. That's when the Civic Association filed that lawsuit and said, no, you can't exceed 912. To the extent that context is relevant, please take a look at the lawsuit, because you'll see that the 2002 lawsuit was very clear that its goal was to enforce that 912 density limitation, and the whole point of that lawsuit was that the county was playing around with that 912 unit limitation through this administrative process, which it shouldn't be doing.
But CCA would not have been able to sue and obtain that result unless the existing law already capped it at 912, correct?
Yeah, I think
it couldn't
you
have
have
just
to-
asked for that because it wanted it, or it had to have based its lawsuit on the existing law at the time.
Yeah, I think that's what separates this case from all of their arguments about this agreement being ultra vires or a violation of separation of powers. All this agreement did was enforce the existing status quo, which at that time had been in place for 30 some odd years, and now has been in place for 53 years, or at least until the 2003 zoning change, which is, how this kerfuffle all
Doesn't
started.
that cut against your argument, though? I guess I'm struggling to see why that doesn't hurt you. Like, if the entire lawsuit is just about interpreting the current ordinance, and now there's a new ordinance, doesn't that cut against your argument that they had the authority to bind, these entities on a new ordinance that's not even before them? Or that's not currently in place? I think it goes to Judge Ganem's point. Could they have violated the ordinance through a mediation agreement?
No,
Compound question.
yeah, and clearly they could not have violated that ordinance through a mediation agreement, because that would have been illegal contract zoning, but they certainly can confirm the status quo. Let me just give kind of a simple example. It's important to understand that this mediation agreement is enforceable precisely because it folds perfectly within the way this development was approved, built out, and sold. So now you fast forward, let's say in 2002, SSIR, or whoever was the developer at that time, let's say the county told SSIR that, sorry, even though you were approved for 912, we've decided we're going to change that to 700. SSIR would be the absolute first person in this courtroom arguing that it had a vested right to those 912 units, that a subsequent legislature could not take those units away. That's precisely the argument that we are making. Our folks bought into a development that was approved, conditioned upon this 912 unit limitation, and now the county, 50 years later, wants to take away those vested rights. And so that's when council talks about this being a mere contract. There's nothing, mere about a contract. The contracts in Florida have constitutional protections. Article 1, Section 10 of the Florida Constitution says that the legislature cannot interfere with a party's vested rights under a contract. So we're not talking about a mere contract here. We're talking about the constitutional rights of all of the folks first that signed this agreement that have the right to have it enforced, but then the right of all of the folks that bought into this development based on that 1973 condition that was at the request of the developer.
But don't they buy that knowing zoning ordinances can change, or is it your position that somehow they're all buying it, they're buying properties with knowing that this mediation agreement exists?
And does
that
that
has
go to
not
council's
reduced-
point about it being unrecorded?
Yeah.
But
It's not, they're not on notice, right? Because it's not in a judgment, it's not recorded.
what's different about this is that this is a limitation about a particular development. This is not a limitation that really applies to the land in Captiva. It applies to this particular development. So South Seas was approved at a 912 unit density. It was then conditioned on the 912 unit density. It was then built out. It's completely built out at that 912 unit density. So you would think that the folks, just as SSIR has the vested right not to have the 912 units reduced, all of the other owners in this same development have exactly that same vested right not to have that 912 density unit increased. It's what makes this different from the other cases is the fact that this limitation is applied to a particular development that has already been approved, sold out, and developed.
Counsel, I think there's another difference, though, and that is in the cases that you cite, like the town of Largo and the city of Miami Beach v. Clevelander, those cases talk about the vested rights in the hands of a property owner who has gone through some process to get either approved development agreements or has entered into certain transactions with the government that they're relying on, substantially relying on, and that have real value. Whereas you're representing an association that is alleged, I'm sure it's not disputed, that some members of the association own property. But even one of the cases you cite, the town of Largo case, says the mere purchase of land does not create a right to rely on existing zoning. So you might have individual landowners who bought land understanding that this is what the zoning says, but they didn't do the work of getting the development agreements approved or or all that. They don't enter into that same position as the vested rights holders in the cases that you cite. How would you get them to occupy that same status as, say, SSIR or another landowner who's actually gone through these processes to get government concessions and things that they can legitimately rely on?
Just step back a second. The right that we're enforcing is this contract right that was entered into in 2003. I'm making this point about the vested rights to address counsel's argument that there's something that's somehow unfair about this, what they term a forever limitation or the tying in the hands of the government. All I'm saying is that there are all sorts of contracts and all sorts of situations where the government's hands are effectively tied. SSIR, as I said, would be the first to come into this court and argue that that the government's hands were tied forever in connection with their 912 unit limitation. So the point I'm making is not to ask for this court to rule that our clients had a vested right. What the point I'm making is to suggest that when you say that you can't have contracts that affect the government going forward over the long term, that's ultra virus. And the point I'm making is, no, there are all sorts of contracts that create all sorts of rights that tie the hands of the legislature going forward. So you have cases like the Childs case and the Gadsden case, where the Florida Supreme Court specifically says that it's not a violation of separation of powers just because a contract that one governmental entity enters into is going to tie the hands of a future legislature who can't interfere with that contract anymore. That's really nothing more than a recognition of Florida's constitutional protection for contract rights.
But are we different? Is it different because we're in a police power situation here where the county, if the legislature has this obligation to create these ordinances that make sense for particular barrier islands, which are unique, what if it went the wrong way? Like, isn't it sort of dangerous to allocate this power to someone else and take away their police power? So why I'm saying that is, what if hypothetically the situation was that they had contracted to always be able to have 912 you have to, for whatever reason, right, you have to have 912, and then they looked and they said, no, we've got to amend that ordinance. They have to have way fewer there because these barrier islands need to be protected. You could only have 500. And then your client came in and said, no, this agreement says we have to have 912. And the county said, that's really dangerous. I mean, it works better, right? Because now the ordinance allows you to increase, but wouldn't it be dangerous if it cut the other way? I'm not sure if I'm following the sense of
your question.
Okay. I'm concerned about taking away the police power, the zoning power, the power to decide how many units can be on something. I think that in certain situations, perhaps in this one, you say the max can be 912, everything might be fine. But if it went the other way and you said, they have to have a minimum of that. I mean, I know that's
Yeah.
like an extreme, why would that ever happen?
I think the difference is whether you're talking about this happening on the front end or the back end of the development. If this happened on the front end of the development and we were trying to enforce this contract before anything was built out, I think, and before it was approved, then I think you'd
Okay.
have a classic case of potentially illegal contract zoning. But this is taking place at the back end after the development has already been approved, after all of those considerations have already been, have been looked at by the county in terms of how much density should you allow on a barrier island like this, and the ordinance has been passed that has that specific limitation. When the agreement does nothing more than tie the government's hands to that status quo that is already existing on the back end, then you don't have any of the problems of this separation of powers or contract zoning. And
Counsel,
I think this
Can I ask you about contract zoning? Because we understand, I think everyone agrees that, for a county to make an agreement with a private party to enact a particular zoning ordinance, or not to change a zoning ordinance, that's considered illegitimate as contract zoning. And under the Hartnett case, that's based on I think a transcending principle that it's wrong for a municipality to contract away its police powers. Why wouldn't contract permitting be illegitimate for the same reasons that contract zoning is illegitimate?
Well, they say contracting away their police powers. I think this separation of powers argument is just absolutely overblown, because if they're right, counties and governments can never enter into a contract. Every contract that you enter into ties the hands of the parties, and that's no less true for the government. If I'm a legislative entity and I enter into a 50-year contract with the Tampa Bay Rays to build a new stadium, well, there are all sorts of things for the next 50 years that the county or the city or the state or whoever enters into those agreements is not going to be able to do. Every agreement ties your hands going forward.
But doesn't the agreement have to be legal at the time it's made? And I think that's the problem
Right.
here that we're struggling with is, if we could determine that this agreement was not legal at the time it was made, and then all those other considerations are off the table. I mean, it has to be a legal agreement before any of these other principles come into play.
Absolutely. And so what are the arguments they have that it's an illegal agreement? First, they argue contract zoning. But I think it's absolutely clear, looking at the cases, that this has nothing to do with contract zoning. And in fact, in their brief at pages 39 to 40, they say, well, yeah, technically this isn't contract zoning, but you should treat it like contract zoning.
Well, that goes back to my question, why isn't contract permitting just as bad if what the county's doing is contracting away its ability to say, because contract zoning's bad because, zoning's supposed to be decided by the county in the exercise of its police power. And if they enter a contract, then the fix is in. They're not, they wouldn't subsequently exercise their independent judgment on whether to enter a zoning ordinance or not create a zoning ordinance. On the permitting side, I think it's even perhaps more problematic, because I think we've heard, maybe you disagree, that once a party who applies for a permit satisfies all the legal requirements for the issuance of that permit, then the municipality has no discretion to say, no, we're not going to give you one. But so how could it be okay to enter an agreement with a private party to say, hey, we're not going to give permits to people when they otherwise satisfy all the requirements for them?
Well, first, this distinction between zoning and a building permit, I mean, the building permit here is just the vehicle for enforcing the 912 unit limitation that was the condition upon which this development was approved. So I don't think the evil of contract zoning, what the cases all focus on, is that you do a deal that's completely outside of the process without going through all of the steps that you have to go through to determine whether the zoning is appropriate. Our point is that when you reach a deal like this after the fact that preserves the status quo, you are, in fact, it's the opposite of contract zoning. because you're confirming a process that has already been taken place. So you're not circumventing the process, you're affirming that process. And the building permits just happen to be the vehicle for affirming that process. So it's the combination of this agreement that was entered into with very plain language by the county voluntarily. So all this stuff about, taking away their police powers, this is an agreement that the county wanted to do. They wanted us to drop that lawsuit, and so they signed this paperwork. Nobody forced anything on them. So when you look at it that way, and you look at it preserving the status quo, there is simply no interference with any police powers. I remember it was the Gadsden case or the Childs case, but it specifically says the fact that you're arguing that this contract is going to somehow tie the hands of a future legislature is wrong. That does not violate the statute, a separation of powers. So for all of these reasons, we think the contract means what it says and that it was perfectly enforceable. It goes back to how this development was approved and built out, and we think that this court should affirm.
In 1972, all those property owners in the north end of Captiva Island, the status quo was that there was 3,900 dwelling units. And in 1973, the law changed and there were 914 dwelling units. I've heard the word status quo about 20 times in the last 20 minutes. The status quo was governed by the law. And what he is saying is that he wants to have the right to control the law for an indefinite period of time for a private association. And that's not a contract that they could have ever entered into. The discussion about, well, governments can do long-term contracts. They can do it for stadiums and things like that. Sure they can. But this is a police power. And the cases that you're citing that are so-called, contract zoning cases, what are they? There's someone who doesn't want to live with the status quo, wants to change it for their own one piece of property. One owner says, for this project right now, I want to be outside the law. I want to be able to do it this way, and you can't change your mind about this after I start building. And those contracts, we've repeatedly said, are delegating police powers, and that they're not valid, enforceable contracts.
But do you agree that those are distinguishable cases, that the true contract zoning that we see in there, it's unlike, it's not a mirror, or it's not an exact match for what we have in this case. Do you concede that?
It's not an exact match because this is the extreme version of it. Here we have someone who is not even a property owner at all coming forward and saying, I want an agreement not just for one parcel, but for an entire zoning district. And I want an agreement that the status quo, which is the current law, is going to stay that way forever, that you can't change the law, that the next county commissioners that are elected can't change the law. That's what's going on here. So if it is ultra-virus to do this for one property owner, for one lot, for one project, it's 1,000 times more unconstitutional to do it in this context for this private association, to give them these rights. And this is not a separation of powers issue, by the way. I have not argued that. There was some brief issue we argued below that was that. But we're not separating powers between three branches of government. We're giving control of the building department to a private association. And that's simply not legal. So unless this board has additional questions you'd like to ask me, I think I'm finished. Thank you very much for your time.
I want to thank both councils for their argument and their briefing in this case.